जो लोग कॉन्स्टिट्यूशन बनाने के माहिरीन थे उनमें ज्यादा अकल और दानिश थी, उन्होंने 73 का आइन बना दिया। और उन्होंने एक साहब टहलते हुए आए, उन्होंने कहा हो कहीं ये लोग सर ना खड़ा कर लें तो ऐसी चीजें डाल दो इसमें कि हर कोई जो मेरी मर्जी हो मैं उसको डिस्क्वालीफाई कर सकूं। अभी इस बात को हम क्यों नहीं कह रहे हैं, इसको बात का एतराफ क्यों नहीं कर रहे हैं? तो समीउल्लाह बलूच स्पेसिफिकली मेंशंस दैट इट वाज इनकॉर्पोरेटेड बाय इन द ड्यूरिंग मिलिट्री टेक ओवर।
बिल्कुल बिल्कुल।
सो आई मीन
द रिवाइवल ऑफ
I don't know why we so
1985 but 18th amendment में
niceties of grammar and English and we are forgetting the overall picture.
18th amendment, the problem is that
18th amendment भी वही मसला है ना कि इधर आपने देख लिया क्या हालत हुई थी पाकिस्तान में, वो भी हम क्यों नहीं बात कर रहे हैं उस बात की? जरा सी उन्होंने लैंग्वेज बदल दी तो उन्होंने पता नहीं पूरा पाकिस्तान came to stand still. We must realize that there are issues which are exploited for personal ulterior motives.
My lord,
gain certain political advantages. Now, once we are not a court of law that we should shy, we are not that we should shy away. We are a court of law, upholding the Constitution of Pakistan. Constitution does not, rightly or wrongly, does not provide a time period. Why should I fill in what the Constitution has intentionally left, even if I accept it at par with every other constitutional provision, something brought in by a military dictator? भाई उन्होंने नहीं किया, वो जाने, मैं क्यों काम उनका करूं? नहीं आपको जरूरी करना है, क्यों? भाई देखें, absence is also a decision. If I don't decide to do something, I'm deciding something. Parliament has elected to remain, leave it aside. We also leave it aside.
My lord,
अगर वो कल कोई कानून साजी करेंगे हम देख लेंगे उसको।
Mubashir Hassan case में my friend Ahmed Qayyum read out paragraph 115 from Mubashir Hassan where the full court held that 62 is not a self-executory provision. 62(1)(f) is not a self-executory provision.
And they were judges थे?
जी, sir, it was a full court. It was, I believe, 15 or 17. Full court थी, sir.
What context was that?
So they were looking at examining 62(1)(f) because it was NRO which was under challenge. NRO under challenge था तो उसको वो देख रहे थे and उसमें 62 को उन्होंने examine किया 62(1)(f) को and they went on to hold that it is not a self-executory provision, and by that I think it doesn't explain it in that detail, but perhaps the rationale behind that was that because there is a declaration by a court of law which is required, then there is a law or several laws must also provide some mechanism how that declaration is to then come out.
I mean,
now what has happened here is that 232(2) provides a time frame for the longevity of that declaration, but it does not then address the 4 questions which were left open by.
I mean, this constitutional silence has really got us.
नहीं sir, अब आप उसका ये कर सकते हैं. Options here. Either you leave it to the parliament. Elections are around the corner. Leave it to the parliament.
Then what is the status of this provision?
So this provision is, as the Supreme Court held, is not a self-executory provision. It requires making a law. The law has to be made. And that is for the parliament to do.
नहीं, अगर ये इन्होंने wording लिखी है specifically, मैं मुबशिर हसन देख रहा हूँ. मुबशिर हसन में जरा गिनते हैं 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 17
पैराग्राफ 115
115 में 17 जजेस हैं, यानी कि फुल कोर्ट. It is true that अच्छा the provisions of Article 62 of the Constitution cannot be pressed into service because it is a provision of Constitution which is not self-executory.